All right. I think we can go ahead and get started. We were waiting for a few more, but we'll leave the door open for anyone who may trickle in. Hello. For those I haven't met yet, my name is Frank Gilligan. I'm the Assistant Commissioner for the Securities Division. And I would like to welcome you to the Regulators Forum. We are live streaming this as well, so anyone who is listening via the internet, if you have any questions, please email Stephanie Willoughby, and she will give us those questions. Everyone in the room, please feel free to ask any questions you may have in the course of this discussion. The intent of the forum is really just to meet with members of the industry and provide an update as to what's happening in the regulatory arena, what's new with the Securities Division, and what our priorities are for this coming year. So I hope this is much more of a discussion. So if there are any topics you would like to discuss, please feel free to ask, and we'll do our best to address those. I first just want to introduce those on the panel, but before I do so, I want to give a special thanks to and introduce Stephanie Willoughby, who is in the back there. She is our Investor Education Coordinator, and she is largely responsible for putting all of this together. So she did a great job in doing so, and thank you. To my immediate left is Elizabeth Bowling. She is our Director of Registration. Elizabeth oversees our registration section of, I'm sorry, hold on one sec. Are we having technical difficulties, or are we okay? A little louder? Okay. All right. Elizabeth oversees our registration section, so she's responsible for ensuring that all broker-dealers, investment advisors, agents, and reps are registered. She oversees the registration of offerings, and she oversees our examination program, which conducts the post-registration exams. To her left is Casey Wolf. Casey is the Chief Counsel for the Securities Division and the Insurance Division. She's been with us for a couple of years, but she came to us from the Arkansas Securities Division and really brought a wealth of knowledge of securities regulations with her. And to my right is Chris Clausey. Chris is fairly new to the division. You've been with us since February? Yes. Okay. And Chris came to us from the Franklin Police Department. He was a lieutenant with Franklin Police Department and also worked in their Human Resources Department and oversaw a lot of community policing programs, and is really, in the time that he's been here, provided excellent leadership of our enforcement section. So I would like to start off by just talking about a few things that are new with us. Primarily, we have a new Securities Bill, which hopefully will become a Securities Act very, very soon. Our bill was passed in the House and the Senate and is currently awaiting signature by the governor. This bill, what it does is there are two primary functions of this bill, which we'll talk about. The first component of the bill is our senior protection statute, and I will discuss that in fair length. The second part of the bill is our securities modernization portion of the bill. And in crafting this bill, and we worked on this for probably over a year. We put a great amount of time and resources in doing this, and it was one of our priorities last year. So I'm very pleased that it did pass both the House and Senate and is awaiting the governor's signature. So when we sought out to construct this bill, we reviewed the entire Securities Act and looked for any provisions that were obsolete. We tried to update it wherever possible to essentially bring the Securities Act into the 21st century to make compliance easier. And we really tried to strike a balance, especially in the senior protection portion of our bill. We tried to strike a balance between investor protection and continuing to foster the securities and investment business or industry in the state. So I'm going to talk a little bit about our senior protection portion of the bill. And you should have in your handouts, there's the large stapled papers is the bill. Section 127, which should be toward the very end, is the senior protection portion of the bill. So what this does is it provides protections for those seniors and other vulnerable adults. Vulnerable adults is essentially refers to individuals who have certain physical or mental disabilities. It provides protections to those individuals from senior or from financial exploitation. So we looked at several different options when we construct this statute. And if you are familiar with the NASA Model Act or some of the senior protection bills that were passed in other jurisdictions, ours is very similar to those bills. However, we made a few adjustments. Primarily, we decided that it would be best to choose a permissive reporting requirement as opposed to a mandatory reporting requirement. So what this does is it allows for the broker-dealer, the investment advisor, the agent or representative to report suspected financial abuse to the Securities Division, and it provides immunity for doing so. Many jurisdictions went with a mandatory reporting requirement. Ours is a permissive reporting requirement with immunity, which I think is largely in line with our philosophy of trying to really balance investor protection with fostering the industry. However, I do want to make you all aware that there are also other bills out there. Specifically, you would want to look at House Bill 0810, which was passed in the state, and I'm not sure about the Senate at this point. Casey, do you happen to know if it was passed in the Senate? Okay. I checked this morning, and it hadn't passed in the Senate, but that may have not been updated. This bill is not one of our bills. This is a bill that actually makes it mandatory to report to Adult Protective Services, and it makes it a Class A misdemeanor for failure to report. So that's something that I just want to make sure that you're aware of that, because that is different from our bill. Okay. I don't. All right. Well, I'm not really sure. Is that a little better? Okay. All right. I will try to keep this microphone as close to my mouth as possible. Okay, so I want to just make you aware of the various bills that are out there, but the one that specifically deals with the securities industry is a permissive reporting requirement, which gives permission to the broker-dealers and investment advisors to report to the Securities Division. A provision in that statute also allows the qualified individual to designate a third party to be notified. This is similar to a trusted contact form. However, we broadened that a little bit to essentially include anyone who has a legal relationship to the senior. So this will allow you to notify that third party in the event that senior financial exploitation is suspected or has happened. It also contains a provision which will allow you to delay disbursement of funds in cases where senior financial exploitation is suspected. The delay is for 15 days, and that can be extended by the commissioner or by a court of competent jurisdiction. And that is really designed to allow us the time to investigate, to determine if there's proper grounds to continue to delay that disbursement and allow us to open an official investigation. The other important part of the senior financial protection is that we are, it contains a provision which, I think I'm going in and out here, but it contains a provision which doubles fines for in situations where a senior is the victim of securities fraud or other violations of the Act. Currently, I believe the base fine is $10,000 per violation, so this would double that to $20,000 in situations where we have a senior victim. So I'm very pleased that we got that that portion through. And before we go on to talk about the other portion of the bill, did anyone have any questions about the senior financial protection portion? Yes.
Does this just cover clients in Tennessee?
Yeah, that's a good question. It really, the immunity for reporting is immunity for you as the broker-dealer or investment advisor. So it would, correct me if I'm wrong, Casey, but that would include any victims inside or outside of the state. Is that right?
It would, because it's based upon what you find here in the state. However, you should be aware of any reporting requirements in the residency states of your clients as well.
Yeah, that's a good point, because as I said, there are, Alabama, I know, for instance, has a mandatory reporting requirement. So you might want to check with the Alabama Securities Commission to see how they would view it in terms of reporting. Yeah.
If you don't mind, follow up on that is, if we did report on.
The question is, if you report it,
I suspect.
well, to be on the safe side, I would, well, the answer to your question is we would work with the other states, or at the very least we would make sure that a referral is made to the other states. But I would check to see what the reporting requirements are of, in this case, Ohio, to make sure that, if they would require you to report, and I guess it depends on how they would interpret their own statute.
Because, Casey, correct me, but it wouldn't relieve any obligation that you have to the state of Ohio if you report to us, if you have a client that's a resident of Ohio. So you would need to, right, if they have a mandatory reporting requirement, then you would need to make sure that you're meeting those requirements. And saying that I reported it to Tennessee would not relieve you of that obligation.
Right, that's exactly what I was going to say. Yeah.
Yep. Sure. Absolutely. That last question was whether the question was, if you have a client outside of the state, are you required to report to both the Tennessee Securities Division and the out-of-state jurisdiction? And the short answer to that question is to be on the safe side, both, depending on what the other jurisdictions' requirements are. We would make the referral to the other state, but that wouldn't alleviate the reporting requirement.
And really quickly, I think this is a good time to chime in with the legal disclaimer that anything we're saying up here shouldn't be interpreted as legal guidance, because obviously I'm the attorney for the Securities Division, but not for you guys. So take everything you have, and if you have in-house legal counsel or your own attorney, I would definitely suggest running this by them as well.
Yes. Sure. Casey, did you want to, or do you want me to? Well, let me just repeat the question for those who are live streaming. The question was whether, if you had already been using a trusted contact form, does this bill make any additional requirements for the qualified individual as to their record keeping? Is that right? Okay.
And the way that the new law is worded, it allows you to keep that trusted contact form, but it also expands additional parties that you would legally be allowed to contact outside of that trusted contact form. And I'll just go through the enumerated list. It's a relative of the designated adult as defined in 716102, which that would be pretty much your legal relative. So you have spouse, child, including stepchild, adopted child or foster child, parents, including step-parents or adoptive parents or foster parents, siblings of the whole or half-blood, step-siblings, grandparents, grandchildren of any degree, aunts, uncles, nieces, and nephews. So that's in your legal relative category. We also expanded it to a legal guardian of the designated adult, a trustee, co-trustee, or successor trustee of the account of the designated adult, an agent under the power of attorney of the designated adult, or, which this is where your trusted contact form would come in, any other person permitted under existing laws, rules, regulations, or customer agreement. So that would fall under that category.
Any other questions? Yes.
So just a follow-up, so then you mentioned another bill in process. Could you elaborate a little bit on the intersection of the law that just passed?
Sure, and I'll just say I'm not sure whether this passed or not, but it's House Bill 810, and 810 is a criminal. It's a criminal statute, and it requires reporting for suspected senior abuse, which includes financial exploitation. Requires reporting to Adult Protective Services, and it makes it a Class A misdemeanor for failing to do so. So that bill isn't specifically a regulatory bill that's addressing investment advisors or broker dealers. It's a broad bill, and it requires reporting to APS and not us. So whereas our bill would require you to report the suspected abuse to us, I would want to make sure that you're looking at that bill as well, because that may require you to report it to adult. That may mandate that you report it to Adult Protective Services. So.
One follow-up to that, just a small one. If we did report to you, do you automatically?
The question was if it's reported to us, whether we would make that referral to Adult Protective Services. We likely, we would make that referral. We do our best to make any referrals to other agencies or other departments whenever possible. However, that would not alleviate the requirement for you to report to them. It passed the, okay. We're just getting an update on the bill, and it looks like it did pass, so I would check that bill out as well, just to make sure what your requirements are. Any other questions regarding the senior protection bill? Okay. The only other, Stephanie, did you have any questions online? Any emails? No? Okay. The only other things I wanted to talk about regarding senior issues are really just some best practices, things that you all really need to be taking a look at. And that's whether your firm has any policies or procedures in place regarding reporting or spotting senior issues, whether you offer specific training on senior issues, such as recognizing the signs of abuse, knowing when to report, how to report, recognizing signs of diminished capacity. So these are all things that you might want to think about. The other thing that I don't think I mentioned regarding our bill is it does include a requirement that you make available any records that you may have regarding the suspected senior abuse. So, good record keeping is always critical, but that the bill does require you to turn those over to us when requested, so that we may conduct a proper investigation. So if there are no other questions about the senior issues, yes?
Regarding the training
Yeah.
staff, do you provide suggested resources?
Yes, we have a lot of material that we've been trying to put online when it becomes available, and we.
Do you want to repeat the question?
Sure. The question was whether we would provide any training materials, or whether it's the firm's responsibility to find them on their own. And the answer is, to the extent possible, we will try to put as much information as we have online. And we have conducted a few senior training events, and we have one that we will be holding in June as well. So we will get the date. I don't think we finalized the date on that, but we will likely try to hold some type of senior training on a quarterly basis if possible. So, any other questions regarding the senior portion? Okay. Okay. The question was whether the bill that requires reporting to Adult Protective Services, and that's House Bill 810, has passed. It looks like it has passed, and it hasn't been signed yet
into law.
So it's basically the same status as our bill. You can access that by going to the Tennessee General Assembly website, just doing a search for House Bill 810, and you should be able to pull up the bill. So, all right. So next I would like to talk about what the rest of our bill does, which is provides or updates the Securities Act to hopefully make it a lot easier to comply with, and just generally cleans up the act and hopefully brings it into the 21st century. Casey, is that something you can talk about?
Sure.
All right.
And really, we made a lot of little changes that don't substantially affect anything you guys do on a day-to-day basis, but it cleans it up and makes it excuse me, it makes it more user-friendly, and we took out a lot of references to notice by telegram and telegraph. Right. We also we took out a lot of outdated requirements where if you were doing a securities registration, you had to file 3 paper copies with the division. We eliminated that to allow for electronic copies or reference to Edgar if possible. We also put in a provision that outlines renewal registrations. It wasn't specifically stated before, so when you are doing a securities registration, it's a 12-month effective period, and you do renew it each year, and you file that with the division. Some of the areas in the Section 109, which affects broker-dealers, investment advisor reps, and agents, we took out a lot of the outdated language, such as, it has to be filed by noon Nashville time. Well, we're in Central Time, so we just made that small change to say that you have to file it by noon Nashville time, and just fix some grammar issues. We did take out an exemption that was in Section 110 that actually expired in 1990. Since it is expired, we did finally take it off the books so that there would be no confusion. And really the biggest change, we did, if you look in Section 112, we do permit the commissioner to allow withdrawal provisions by rule instead of by order if you do want to withdraw your registration as a broker-dealer agent or investment advisor representative. Just small things that really shouldn't affect your day-to-day operations, but just kind of brings us into compliance in the 21st century. But the biggest overhaul that you'll see is in our covered securities section, if you deal with covered securities at all, which some of you may not. And that's, we really revamped that whole area and allowed for notice filings for Reg A Tier 2, which came into place with the Jobs Act. It became a covered security in 2012. And federal crowdfunding, where you do have to notice file in two certain provisions where you have 50% or more of your offering is located to resident or is to Tennessee residents, or your principal place of business is in Tennessee, then you would need to notice file your crowdfunding filings with us. And that's really what was changed in Section 125. We added an effective period so that each covered security is effective. Their notice filing is effective with us for a year's time, with renewal fees of $100 each on those covered securities.
All right. Thank you, Casey. So in terms of our priorities for this coming year, senior issues that's going to continue to be one of our top priorities. Another top priority for us this year is cybersecurity. And it's obviously a big concern, especially with the most recent ransomware attacks. Concern for protecting your businesses, your clients' information. That is one of our top concerns, and it's going to be a big part of what we will be doing this year. What we have been doing in terms of our exams, and I'll let Elizabeth speak to that a little bit, but we've been getting information as to what policies and procedures you have in place. We're probably going to start digging a little bit deeper to make sure that those policies are adequate. And obviously, we're not going to hold a small solo investment advisor to the same standard as a large broker-dealer. But we really need to ensure that proper protocols and procedures are in place. What we will likely be doing is a lot of investor education in this arena. The more information that we can provide to both investors and to industry, the better we will be at hopefully fending off some cyber attacks and keeping information safe. I serve on the NASA broker-dealer section committee, and last week we met in Washington, and we met with the SEC, and cybersecurity was really the top issue that we discussed. We discussed, among other things, cybersecurity insurance, and I'm not sure how many have that or are aware of what exactly it is, but someone with the SEC mentioned that according to a recent study, 90% of cybersecurity insurance policies are completely worthless. So that's something that we're going to be looking at, and something that you all really need to discuss with your insurance brokers, so that you're making sure that that what you think you're getting in terms of protection, that you will actually have that protection in the event of a cyber breach.
And I'm going to jump in right there,
Yeah.
Frank, because cyber insurance is something that if you have the right policy, it's very helpful and beneficial, and something we briefly talked about last year at this regulators forum, because there's a lot of cost associated with the data breach, because there's legal costs, there's cost of investigation, there's cost of notifying required parties that a breach has occurred. You might have to offer. You may want to consider PR expenses, because if you've got, if your breach is something that reaches the news, then you're going to have to offset that in some way and have the right marketing and PR to respond to any questions that come about. And then also the profits that are lost while you're disabled, and until you can get the breach fixed, corrected, and back up and running. And then there may be regulatory fines if you missed something, if you didn't notify the required parties that you were supposed to, or if there's settlements related to the breach. So, like Frank said, if most policies are worthless, it's more important to have an understanding of what you need and what you're getting when you purchase one, because I think the average cost per record of a financial privacy breach is around $221. So, if you have a lot of clients, then you can get up there in cost. So having that insurance is one way to protect, but it is important to know what you're purchasing and what you're actually getting, because they vary from some insurance policies will cover the cost of PR, will cover the cost of providing some sort of, I can't think of the name of it, but something to your clients that where they could see if there's been any hits because of the breach. So, if you were involved with the Target breach a couple of years ago, you got an email saying, like LifeLock or whatever that a security monitoring service. Sometimes when there's a financial breach of privacy, then that's offered to those who are affected by the breach. So it's just a lot of things to consider. And like Frank said, we're not going to hold a large broker-dealer firm to the same standards as an IA on everything, a small IA, but, you need to find what's the best suit for your firm while still being within the bounds of the law.
Yeah, and I think it's also important to mention, too, that it's not really just an IT issue. It's an overall risk management issue. So it's very important to create that culture of compliance, making sure your staff isn't clicking on unauthorized links or using personal devices to access client information. So it's really important to create that culture. Did you have anything else you wanted to add about cybersecurity, or anybody?
Well, I was just going to say that, it's just because you're not a large broker-dealer firm or not the largest firm is one additional reason to really be aware of cybersecurity issues, because a lot of times the fraudsters know that the smaller firms may not have as many security measures in place. So a lot of times a small firm is going to be an easier target for someone who's trying to do a cybersecurity breach and breach your system, because if you are a lot less sophisticated in those areas, then it's easier for them to get that information and your client's information. So, what we've been doing is looking at what y'all are doing, asking the questions if you have cybersecurity insurance as we conduct the examinations, what safeguards you're using, if you're encrypting, if you're using any antivirus or anti-malware software. And what we're looking at this year is if we need to adopt the NASA model rule on cybersecurity, or if we need to craft our own rule on cybersecurity. But I would expect to see in the upcoming year us look at a rulemaking to address cybersecurity specifically. We can get to it other ways now, but one of our goals we talked about last year with the code was for clarity, and we're now going to take that same thought to the rules. So having a cybersecurity rule that spells out what's expected from firms, then I think that makes it more clear for you and for us as we conduct the examinations.
Great. All right, so now I'd like to turn it over to Chris Clausey to talk about a few enforcement issues and some things that he's seeing in his arena. But one question.
Just real quickly on cybersecurity. So,
Yeah.
you mentioned the 90% statistic.
Yeah.
Grab our cybersecurity. Is there any guidelines from now?
The question is if there's any approved list of cybersecurity insurance providers. And the answer to that is no. I mean, we haven't approved anyone because really the cybersecurity insurance is going to be firm specific. So it's going to depend on what you're looking for. It's not that those insurance policies aren't valid policies. It's just that it may not be what the person expected for them to be. So it's really an idea. It's really more of making sure your expectations are being met with whatever policy that you have, I think.
Yeah, no, I'd say that's correct. So, anybody else questions about cybersecurity? Okay. All right, I'd like to turn it over to Chris to talk about a few enforcement issues.
Well, good afternoon. It's about 12:10, so now it's the afternoon. I can say that. I want to say probably the most important thing that I've seen already since I've been here is the unsolicited investment offers that your clients are getting that are either through an email or a phone call or something like that. It seems like when that happens, that's the big red flag and something that we've noticed a lot of. Some of the top 5 investor threats or schemes that we've seen and that NASA's recently reported on are the Promissory Notes, which is probably the first one, and I think since I've been with the department, it's one that I've seen most frequently. I think in times when we've got the low interest rates, that the promise of a high interest-bearing note really lures people in, especially seniors and especially people on low income. Oh, I got to talk louder too. Thanks. Low fixed incomes. So that's something to be aware of. Also, legitimate promissory notes are usually sent out to people or solicited by people that are real sophisticated and more of the corporate investors. Another thing to be careful of is these short promissory notes that are 9 months or less. Those are not necessarily regulated. Circumstances require that those not always registered is what I should say. So short-term notes that appear to be exempt from securities registration have at times been the source of these problems for investors, and one of the things that we've noticed the most. Not all, but some. Another one that we've seen is the oil and gas investments. The interesting thing about that, and probably the biggest red flag that we've seen, is the headquarters or the partnership is located in one state. Then you'll notice that the site or the well or where the property is going to be is in another state. And then when they're looking for the prospective investors, they go to an additional state. So you've got 3 states involved, and part of the reasoning behind that is that investors are not going to have the opportunity to go a half an hour down the road to look at the site or to visit the site or to visit the headquarters. So that's another one that can oftentimes cause problems. Real estate investment interests. We've looked at the REITs. Those are non-traded, and also the timeshare resales have been a problem for various reasons. And then the Ponzi schemes, which obviously we've heard a lot about. The interesting thing about Ponzi schemes are that those real elaborate Ponzi schemes that bring in the $20 billion towards somebody over postage vouchers or whatever it was that originated. We're seeing a lot of those that are not that big a scale as that. They're done real sloppy, but people are sucked into them really quickly. And those continue to be a problem just because so many different things can be used as the scheme in that plan. So that's something to be aware of. One of the things that I thought was kind of interesting, and I don't want to share the specifics of a case that we have or cases that we have, but we're dealing with right now. There was a case in Austin, Texas, a situation that happened in Austin, Texas, of a promoter in the entertainment industry. This promoter was promoting concert venues and selling promissory notes and the sale of investments for these concerts. And what happened in this particular one is it was about a $2 million fraud. And when this person actually did get caught, there were some significant consequences for that. But anyway, the way it kind of worked out was this investor tried to get this promoter tried to get investors by telling them that they were going to have these really big artists that were going to perform at this concert, and that it was going to take a certain amount of money to get these concert artists there. What turns out to be is that those artists don't show up, and then once they've got somebody on the hook, they'll tell them, hey, look, like we're doing here today. If you want to make even more money, we can live stream this event, and that'll cost a little bit more money, so they just keep getting more and more money. Come to find out that those performers are not going to be there. The money is gone, and the people don't get anything back. From this particular instance, though, what happened was they got 10 years. This person was sentenced to 10 years in prison and had to pay $1.8 million in restitution to the victims. Hopefully, they'll all get it. But that's basically what I wanted to share this afternoon. Did anybody have any questions? Thank you.
Seeing none, thank you, Chris. Elizabeth, can you give us an update on what's happening in registration?
Of course. So we've been continuing with our post-registration examinations. This year we have completed so far, we've opened 94 exams and we've completed 80. 25 of those were closed without deficiencies, which was really good. And then that leaves the remainder of 55 that did have a deficiency of some sort. And I just thought that what I would do is mention some of the common issues that we're seeing in the IA examinations. We're seeing undisclosed social media in the marketing and advertising side. So if you're using social media, you need to remember to disclose that, make sure you're looking at that, and that you've got a written standard procedure for your social media and what your firm's plan is for that. Inaccurate assets under management and IARD, and I think just generally making sure what is in CRD, IARD matches what your firm is doing, and making sure that that's ongoing, that you're looking at that, not just when you filed your application for registration, but IARD is something that you're going to have to be in on a more regular basis, and make sure that you've disclosed what you're actually doing and that those things match. A common item is just missing material for requested exam items. So just basically an incomplete submission. And you can see one of your handouts is post-registration examinations of investment advisors. And those list 27 items that we generally request when we open up an exam. Then we also have seen written disclosure compliance manual concerns, deficiencies in client contracts. You need to remember that you should have a client contract even for family and friends. Just because it's your mom doesn't mean you don't need to get her to sign the contract. I would say from seeing things in the past, that's probably the more important contract to have, so that it's all outlined is with your family and friends. Makes it easier. An out-of-date compliance manual, oversimplified items in your compliance manual, or no business continuity and disaster recovery plan, and no record of ADV or privacy policy delivery. And then just simply there's a net capital requirement, which is $15,000. And when we do these examinations, some firms are not meeting that net capital requirement. And as we've mentioned, cybersecurity, a lot of firms don't have, or some of the deficiencies we've seen are missing cybersecurity documents. So the net capital requirement, I think, is a good segue of an example. Let's see. Let's look at the handout that talks about investment advisor compliance, frequently asked questions. The first item is, where can I access the Tennessee Securities Division laws and rules? And it gives you a link. I mean, it gives you a address to find those. And there are there's a link to the code and also to the rules. And I can't stress enough that the rules that apply to investment advisors, you should be familiar with those. Part of your obligation as being an investment advisor is to understand what those requirements are. So I know this year we sent out an email reminding you of your annual reporting requirements. And we'll typically, we'll try to do that. But ultimately, it's your responsibility to know what applies. And that goes back to what our goal for this year is, to make those rules as clear to you, to know what those expectations are. So I think it kind of goes hand in hand. the net capital and the annual reporting requirements, we've got a handout that covers that. Those are just kind of some questions that we encountered this year and last year as we did that. So every year you have to submit your annual balance sheet, but the net capital requirement is that you maintain that net capital throughout the year. So even though you're reporting once a year to us, this is something that we should be able to pull a balance sheet on a monthly basis and see that you have consistently maintained that net capital requirement. And the handout goes into a little more detail about what the requirement is for that, and then also for the annual ADV amendments. We still have a few firms that have not met these requirements who had fiscal year ends in December, so I'll be sending out a couple of notices to those firms in the upcoming week. And then if your fiscal year end is not December 31, we have 5 or 6 firms that have a different fiscal year end, then you need to be, we'll be looking at those. I think we have one that ends in March, so that whoever you are, if you're watching, your balance sheet and your ADV need to be done by the end of June. And I wanted to mention the common deficiencies, talked about the annual reporting. We've got this handout, and I think it was included with the email for those of you that are watching live stream. So you've got access to that. And we hope to make these available on our website soon. And we're looking at, as this, when the bill becomes an act and we have changes there, and as we look at the rules, all the documents that we have on the registration side of the website, we're going to be looking at reviewing and trying to update. So hopefully these will be out there soon. And then as far as the FAQs, we'll add to those as we see fit and as is needed. We've talked about cybersecurity. And then briefly, I talked about the rules, but I think that there's a lot of areas that are under our authority to examine you on, but maybe are not as clear in the rules as we would like them to be. So that's something that we're looking at this year. Again, just taking a look at each section, and specifically with those dealing with the industry, trying to make those more clear, easier to understand and find, because it is something that you are responsible for knowing as a registered investment advisor. And our goal this year, or my goal this year, is to make that as easy for you as possible.
Great, thank you. Does anybody have any questions about any of what Elizabeth was talking about? Yes. Sure. The question was, if you have a question regarding the interpretation of a rule or the statute, who can you contact to clarify that? Elizabeth or Casey, do you want to jump in here? I guess I'll start off. The quick answer to that is you can call. All of our information is online. Feel free at any time to call myself, Elizabeth, Casey, if it's an enforcement issue, Chris. To the extent possible, we will try to clarify that. However, if it's an issue that is a legal interpretation, we can't give legal advice. So anything that's quick and easy, we'd be happy to clarify for you. However, if it gets into that gray area where it may require some legal interpretation, we'd probably refer you to an attorney in that regard. But
and that's what I was going to say. my answer was going to be Frank's answer, which is, we'll try to help as much as we can, but we can't give general business advice. We can't give legal advice. We can, if there's something that you really have a question about, then you're always welcome to ask for an interpretive opinion letter from the legal department. Well, that would come through us. Casey?
Right. That's in the first chapter of the rules. There's a mechanism for which you can ask for a legal interpretation, and it's called an interpretive opinion. You have to put the specific facts, and it's published in public information, so it depends on if you want to go down that route. And it's something that we would take a look at and say, although this is not legal advice, this is how we interpret the statute. Those are available in certain circumstances, and not every circumstance is right for an interpretive opinion. It is very case by case. However, I know that Elizabeth and her staff are very helpful and knowledgeable and willing to work on the small issues that can easily be ironed out that says, oh, well, no, we accept this in so many days, or, I know this says this. But for the most part, if it's going to be very, do I have to comply with this? Are you saying that I need to do that in order to satisfy? A lot of times it's going to require you to have your own legal advice on that, because we can't say, oh, yeah, if you do this, you're going to be completely fine. That gets into some gray areas that we don't really like to go into.
Hope that helped answer your question. Does anybody else have any questions? Yes.
I didn't bring my rules with me, but I believe what the rule says is that within a reasonable amount of time that what you have in IARD, and I believe in some areas it says specifically 30 days. So generally, if there's a change in what you've reported through IARD, then you should be making that, like if you have a change in your practice, then what you had previously reported, the general timeline is 30 days to then update through there.
And the question was how often do you need to keep your AUM up to date? Any other questions? Okay, Casey, can you update us on anything that may be happening in legal or?
Well, we don't have a ton of legal updates besides the Securities Bill, which we're very proud of and excited about. I do want to give you just a general overview of our legal division, because we are not a part of the Securities Division. So there's a general civil legal section in the Office of General Counsel, and I am Chief Counsel over securities and insurance. And so I have 3 attorneys that are dedicated specifically to securities. So there's 2 attorneys who primarily do the administrative litigation, where we get enforcement cases that come over mostly from Chris's area, although there are some cases that have come over from Elizabeth. And they'll file the notice of hearing and charges, and they'll do a hearing in front of an administrative officer, and usually that levies fines. And for the most part, it's unregistered activity is what it is for the most part. So I have 2 attorneys who are seasoned litigators, and they specifically handle those cases. And then I have 1 newer attorney who just handles program work and helps guide the Securities Division and day-to-day things and other questions that come up, as well as working heavily in the registration section and looking at the new rules that we want to promulgate and that will come down, and any changes we want to make there.
Great. Thank you, Casey. I'll just add that Casey's done a tremendous job at leading the legal team, and we've really got a great group of attorneys. So
I'm going to chime in on one thing she said, where she said the registration had submitted a couple of cases to the legal department, and those mainly were people who make sure that you've got money in your account in IARD, because we had we're looking that if you don't renew your registration, if it doesn't renew on 12/31, then we're monitoring that. So if we don't want you out there advertising, conducting business as a registered investment advisor, if you're not truly registered, we have a problem with that, and we will be contacting you. And that is one cease and desist that we just had signed last week. So,
and I think just one more other area is when someone is unresponsive to the registration section. And I know that Elizabeth and her team are very generous and are very flexible in working with you guys. But if we just have someone that just completely doesn't respond and ignores us at every step of the way, then usually that's referred over to legal, who it could either be a subpoena or other matters to try to get that information.
Yeah, and we often will get Chris's team involved in situations like that as well. So I think we are about out of time. Do we have questions? Okay. You want to?
I can comment on that. That's always that language. That's not a new section of the code. It was cleaned up from the previous language. I believe that previously it said that cost of the examination would be borne by the person examined in the same manner as is then provided for insurance companies. So we just changed that to, rather than refer you to the insurance code, to clarify what we mean by that. That is not something that we're going to start doing. We are looking at the way we conduct post-registration examinations. We've been doing them remotely this year. We don't come into your firm. We will be doing some, and we're looking at, and as Frank talked about last year, and as we've reviewed our policies and procedures for the examination program, we're looking to make changes that we think are more efficient for both industry and for the division. And conducting remote exams is one thing that we're looking at. What we envision at some point is so that we can still have we want to look at these 15 client accounts or client files, and we want this information, rather than you having the opportunity to prepare those files. It may be more of, all right, we've got this examination scheduled for your firm, and on this day we're going to need your compliance officer available, and we're going to, we'll have a request that we provide to you on that day, and we'll need the response, in a reasonable amount of time. We haven't determined, but maybe an hour or 2 hours. So it'll be blocking off some time, rather than us coming to your firm every time we do an exam and spending 2 or 3 days there. Again, it'll be remotely, but it'll still provide some of the protections that we want for our examination program. And that's kind of where we talked about, if you find that is not, if that's the way we're going to conduct the examinations, and then we say we're going to need someone available that day so that we can communicate, and then they can provide us those documents that day. If that's not something you're interested in doing and you'd prefer for us to come out and do the examination, then that is a time where we might enforce that section of the code. But just on a general basis, the post-registration examinations are not something that we're going to begin charging for regularly, but that provision has always been there for the division to enforce as it deems necessary.
So one other question in the back. Yeah, the question was regarding the fiduciary rule and whether we had any comment on that given its current status. And is there anything you want to add regarding fiduciary standard? Or
Considering its current status, right now we're still evaluating and don't have anything.
Yeah, I think we're all in the same boat there. It's just a wait and see approach. Yeah. Any other questions? Yes. Oh, yes. Okay. The question was regarding anyone having trouble filing the professional privilege tax, and unfortunately, that is we deal with that often. And Elizabeth is usually the person who gets the phone calls. So
I believe that they're taking those through the website only now. The tntap.org is the Department of Revenue's website, tntap.org. I'm trying to think of some of the questions we've had. If you don't know your Tennessee Department of Revenue professional privilege tax account number, there is a way that you can look it up. You have to, it's on the bottom left hand of the screen, and it says, I think it says look up Profi account or something along those lines. And it gives you a location where it takes you to a page where you put in your name. You would put in for the license type, if you're paying this for your firm, then you would put in investment advisor. If you are if you're also like an agent through a broker dealer, if you're paying that as an agent, then you would put in agent, and it's in parentheses securities. Then the third blank on the third box on that page is it says license number, and what they want is your CRD number. So if you're looking for your firm's account, then you're going to put in your firm's CRD number. You're going to put in investment advisor as the license type, and the firm's name. If you have difficulty with that, then you can call me. I understand the wait with the Department of Revenue right now is significant, so we'll be happy to help. We don't have control of their system. We can't look at their system, but we may be able to access some information more quickly for you. Again, we mentioned this last year, and I know I helped a couple of y'all straighten it out, where you were paying an investment advisor professional privilege tax, and then you were also paying it as an investment advisor representative. Investment advisor representatives are not subject to the professional privilege tax, so if you're paying it at the firm level as an investment advisor. If you're also registered as a broker-dealer agent, then you may be responsible for paying it for you individually as an agent, but you shouldn't be paying it shouldn't be paying more than $400 a year if all you are is, say, a sole proprietor investment advisor, and you're just an investment advisor representative. Then all you should be paying is at the firm level. So, if you're duly registered, if you're a broker-dealer agent and you are registered in the state of Tennessee, then you as an individual would be responsible for that broker-dealer agent. And then because the firm, yes, the tax is applicable to investment advisors, the firms, to broker-dealers, and then to broker-dealer agents. I don't know what the Department of Revenue stance is. I know, for example, if you're a CPA and also an investment advisor and also a broker-dealer agent, I don't know if they make you pay $1,200 or $400, but I do know that if you're just an investment advisor and an investment advisor representative, you shouldn't be paying more than $400, according to the Department of Revenue.
Yes. So he's talking about some difficulties that he encountered and some things he learned, and one is the professional privilege tax account number has a leading zero that you may not be aware of. So it should be 07 and not just 7. It shouldn't start with a 7. But if you're having difficulty locating your account number, you can contact me. You can contact Michael Lee. You can contact James McDowell, and we can help you get that information.
from the Department of Revenue, and hopefully not make you wait on hold for 57 minutes. So we'll be happy to play a little bit of an intermediary for you in obtaining the information that we can. So if you've got questions about that or you need your account number, then we'll be happy to help.
Great. Any other questions? Final comments? No?
I will say that if you go back and study the bill and you just you're really confused about something, or if you have a question or a follow-up, please feel free to contact me. I'm more than happy to talk about it with you. Again, can't give you any legal advice on it, but I'm more than happy to answer any questions you may have.
Great. Well, thanks everyone for coming. Those who are live streaming, I apologize for any technical difficulties. I hope it came through as clear as possible. Thank you all.